Please. Thank you. Would have seats. We don't have any transported prisoners today. Okay. Commonwealth versus Terry Aaron. Are you Terry Aaron?
Yes, sir.
Good morning.
Good morning.
You're here for a pretrial conference in 25 CR 0081. Why don't you let him get behind the microphone? You get to the side. Okay, right there. You born in 1987?
Yes, sir.
Last four digits, social security number 6691.
Yes, sir.
What does the Commonwealth have in this case?
We will have a felony claim on.
Okay. A motion to tender says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes,
Are
sir.
you the person that we just identified in 25 CR 0081?
Yes.
Okay. Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? And are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes, sir.
Do you believe that you've been fully informed about this case?
Yes.
Do you understand that you do not have to enter a guilty plea? You have certain rights in the Kentucky United States Constitution. I'm going to go over those rights and make sure you understand them. Okay, at the end, I'll ask you, you have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented at counsel at your jury trial. Your right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. Right to part of the Commonwealth proving on a reasonable doubt that you're guilty charge against you. Understand that by entering a plea of guilty, you give up all those rights. Understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence prescribed law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will order a pre-sentence investigation report done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you will have the right to withdraw your plea and proceed to trial. Do you understand that?
Yes.
Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of controlled substance first degree methamphetamine, the defendant shall receive a sentence of 2 years, probated for 3 years. Probation is to be supervised. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Okay, you plead guilty of your own free will.
Yes.
Okay, knowing your constitutional rights, as I previously explained to you, is still your desire to proceed with the plea of guilty and allow the court to fix your punishment within a range permitted by law.
Yes, sir.
You understand that after entering a guilty plea, any future convictions could be enhanced as far as range of penalty under persistent felony offender law.
Yes, sir.
Is that your signature on the document?
Yes, sir.
I'll accept the agreement, order a PSI and schedule sentencing for February the 26th. You need to meet with the probation and parole officer. If no complaints, you can remain fee free, and the court costs will be assessed at sentencing. Okay.
Okay.
Okay. Amanda Adkins. Commonwealth versus Amanda Atkins, 26 CR 001 for arraignment. Where is the arraignment document?
Yeah, it is an arraignment, but it's also, there's a right to document.
Yeah, I understand, but I have to arraign her even if it's on the information. Are you Amanda Atkins?
Yes, sir.
Good morning.
Good morning.
You appeared today on an information charging you with possession of drug paraphernalia and possession of controlled substance first degree
Yes, sir.
meth. You're on the rocket docket, so you're entering a plea today, is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
You just plead freely and voluntarily given.
Yeah.
Same person that we just identified in 26 CR 001. Is that you? The
Yeah.
one that we just identified, the same information. Is your judgment impaired today in any way?
No.
We'll discuss this matter with your attorney. Are you satisfied with his advice?
Yeah.
Have you reviewed the information the Commonwealth has against you and you believe you're fully informed about your case?
Yeah.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky, United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna go over them, and then I'll ask them. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter at higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand by entering a guilty plea today, you waive those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I have to accept it prior to accepting any recommendation. I will wait the pre-sentence investigation report. Now, this is a felony pretrial diversion, right?
Yes, yes.
Okay. It's a felony plea or pretrial diversion?
It's pretrial.
Diversion, okay. So I will ask you some qualifying. I don't have to do the pre-sentence investigation report now because it's a pretrial diversion. So I'll ask you, you understand what a pretrial diversion is. If you successfully complete the program, your case will be dismissed for pretrial diversion. But if you don't successfully complete it, it can be revoked, and I'll have a pre-sentence investigation report done. Then you'll be sentenced to be convicted felon. It can be used to enhance your future. I'm going to ask some qualifying questions. Have you been pretrial diverted in the last 5 years?
No.
Had any felonies in the last 10 years?
No.
Are you presently on probation?
No.
Okay. Now, what is the Commonwealth's recommendation, Mr. Hanley?
Your Honor, upon a plea of guilty to possession of a controlled substance, first degree, namely methamphetamine, the defendant shall receive a sentence of 2 years, pretrial diverted for 3 years, with the diversion supervised. The defendant shall be assessed and follow any recommendations of the social service clinician. She shall receive credit for time served, and as part of the diversion requirements, she shall obtain gainful employment or do a minimum of 30 hours community service per week until gainful employment is obtained. The defendant agrees to have any evidence in the above case disposed of in a manner consistent with the laws of the Commonwealth.
Is that your understanding, Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment information?
Yes, sir.
Doing so your own free will?
Yes, sir.
No, constitutional rights explained to you. Is it still your desire to proceed with the plea? Is it still your desire to proceed with the plea
Yes.
after I've explained your constitutional rights to you?
Yes, sir.
Is that your signature on the document?
Yes, sir.
I'll accept the agreement, sign the diversion order. You need to meet with the probation and parole officer there and give them info. What does the court cost?
$190.
$100. You need some time to pay that?
Yes, sir.
Yeah, I'll let you pay it $30 a month, first payment 30 days from today. Okay? Thank you. Daniel Appleby.
Your Honor, this is a case where it's a flagrant non-support case, and we had him extradited from Missouri several months ago, and we didn't realize that it was a show cause warrant rather than an indictment warrant. And I just want to make sure there's an indictment warrant in this case with no bond set, so when we put him back in NCIC, we can hold him until we can dispose of the case, rather than him being released like he was the last time.
Do we have him now again?
No, I'm just asking for the warrant to be issued correctly.
So he was supposed to.
Not that anybody did anything incorrect last time, I just
Was
want
he supposed to be here today?
No, he was not,
Okay, well,
because I've got to get the warrant correct before I put him back in NCIC.
So there was an active show cause warrant
There was.
and he's released on that.
Yeah, Mr. Brown somebody from his office went to Missouri, got him, they kept him until he served out of whatever the money was, and he was released, went back to Missouri. He's still not paid any child support since that time. And now I'm asking for a warrant under this indictment with no bond, so I can put him in NCIC, so when we go get him the next time, he'll be where we can find him and he'll be in court.
I'm assuming that he's on probation.
That's correct. Yeah, and we've got a motion to revoke his probation filed. We just need the correct one.
Okay.
Thank you.
Tanya Burton. Says active warrant.
We'll put her in CIC.
Beth Garman. Beth Garman.
That's Stephen Bowman's response, and he is on them late, but she is also in the hospital. He's got 4 lane over, he can't be this one.
He's what?
He has 4 and over, came down this morning, he's gonna be running home.
Okay, come back.
I'm here, Your Honor.
Um,
Okay. What's the story on Beth Garman?
Your Honor, Ms. Garman is inpatient at Cumberland County Hospital. Susan Flowers, the Director of Nursing, submitted a letter yesterday that she is inpatient until at least January 25th. And so we would ask if we could pass this to next month, please.
That's fine, Your Honor. She's supposed to enter a DUI forcibly whenever we do have court, so I just think there's gonna be an issue because of the mandatory time and her health. That's one reason I didn't agree to continue today. I want the court to be aware of it.
When did they say she's gonna get out of the hospital?
January 25th.
Well, that's 3 days from today. Where are we at next week? Anyway, next week's a week
We
off.
don't have court again, go Lincoln County on 12th, February.
Did you hear what Mr. Stockton had to say about the mandatory 120 days on the DUI court?
Yeah, yes, Your Honor. We're aware that she has to serve the 120.
Yeah, I have no discretion on it either, Stephen.
I'm not talking
Yeah.
about that. I'm talking about when you want to appear.
Well, it's kind of a certainty about the hospital stay. I've never had that kind of certainty when I've been sick, but if you want to wait till February or do it in Clinton County, either one, it doesn't matter with the Commonwealth.
If we could wait until February, Your Honor, they're just saying that's the earliest that she could get out because of her
Oh,
condition. I think she got
That's a
COPD and
month. That's a month from now, okay? You know, so we'll schedule it, but she needs to be here on February the 26th, or you need to have a hearing beforehand as to why she can't be here.
yes, sir.
You know. And what, you know, and somebody at some juncture, I'll need some explanation as to why these other charges are being dismissed too. I mean, she got a length of charge, don't have.
she had a driving on, the only other charge of significance was driving on a suspended license. So after I saw her doctor's statement, I get conflicting reports on Miss Garman. I have some people tell me they saw her a month ago. She was in a big way, doing good. And then I get a letter from her treating physician. She's on death's door. So I don't know what to believe. But I was gonna put her under probation 5 years and serve 120 days, but that was the only other charge of significance I thought was the driving on suspended license.
Okay.
Yeah.
Okay, well, she don't need to be here on February the 26th.
Yes, Your Honor.
If she can't be here on February 26th, you need to call the Commonwealth Attorney's Office and schedule a hearing on this thing.
Yes, sir.
We'll get her on by Zoom or something and get this sentence done, and we'll find a place for her in a correctional institution that can house her. You know, I mean, that's just the way it is. If she's not able to go to Adair County, they've got places for people that are serving time, and we'll send her there. Okay?
Yes, Your Honor. Yes, sir.
Bobby Garman, sentencing. He's what? Doing what? They in drug court down there?
Yeah, he was voting to accept it this morning.
Okay. File. Jason Hooks.
We'll have to put him into that.
Okay, you'll need to get closer to one of those microphones.
He's incarcerated in North Carolina, so we'll have to put him over.
Okay, Todd Howard. Todd Howard, this is active warrant.
Yeah. We'll put him in Seattle.
James Hurst, active warrant.
Thank you.
Okay, active warrant, NCIC. Robert Kelly. James Craig. Commonwealth versus James Craig. 25 CR 075. Are you James Craig?
Yes, sir.
Good morning.
More.
Were you born in 1969?
Yes, sir.
Last four digits, social security number 0295.
Yes, sir.
We're here for a pretrial conference. What do we have? Okay. A motion has been tendered, says you wish to enter a plea today, sir. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0075?
Yes, sir.
Is your judgment impaired in any way
No,
today?
sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes,
Have you viewed the evidence Commonwealth has against you?
yes,
You believe you're fully informed about your case?
yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand those rights. I'm
Yes,
going to
sir.
read through the rights. And at the
Yes,
end,
sir.
I'll ask if you understand, okay? You have the right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, the right to be represented by counsel for jury trial. You have the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any sentence provided below. I don't have to. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. Now, I'm going to ask some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Or have you had any felonies in the past 10 years?
No,
Are
sir.
you on probation or pretrial diversion now?
No, sir.
You understand if you fully complete the diversion agreement, the charges will be dismissed pretrial diversion. You can have your record expunged. You understand that?
Yes, sir.
You understand if you do not successfully complete the diversion program, you will be brought back before the court, enter a finding, and court will schedule a sentencing hearing, be a convicted felon.
Yes,
It can be used against you in the future. You understand that?
yes, sir.
Ms. Gordon Anderson, what is the Commonwealth's recommendation in this case?
Yes, Your Honor. Upon a plea of guilty to trafficking in marijuana greater than 8 ounces, the defendant shall receive a sentence of 3 years, pretrial diverted for 3 years. Diversion is to be supervised. The defendant shall pay a fine of $500. The defendant shall pay fine in court cause of the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Doing so of your own free will?
Yes, sir.
Knowing your constitutional rights to steal your desire to give up those rights, enter guilty plea allowed in court to fix your punishment.
Yes, sir.
Is that your signature on the motion at all?
Yes, sir.
I accept the agreement, sign the diversion program, agreement, and you'll need to meet with the probation and parole officer. What are the court costs in this case?
So the court cost of 190 plus the fine is 690,
What was that on the insurance or?
it's just a fine.
It was a negotiating part of it.
Yeah, it's not a DUI, right? Okay. Will you make payments of $100 a month? Can you do that?
Don't, that's,
What can you
draw
pay?
social security disability.
Can you pay $50 a
Yes,
month?
sir.
Okay, well, I'll let you pay $50 a month. The first payment's made 30 days from today, okay?
Thank you.
Yeah, meet with probation parole officer. Kinsley Maggart. Commonwealth versus Kinsley Maggart, 25 CR 0083. Are you Kinsley Maggart?
Yes,
sir. Okay, well, good morning.
Good morning.
Were you born in 1997?
Yes, sir.
Last four digits of her social security at 1987. You have an attorney, Ms. Maggard?
I had Rutherford.
Okay, I'll continue the public advocacy represent.
Okay.
Okay. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging possession of controlled substance in the first degree, possession of controlled substance first degree fentanyl, and possession of drug paraphernalia. You understand what those charges are?
Yes, sir.
Counselor, you acknowledge the identity of your client receiving indictment. Waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order. It requires the Commonwealth to give your attorney information necessary to prepare your defense. If I gave you a drug test today, could you pass it?
Yes, sir.
Are you on any kind of medication? So,
No.
well, I'm gonna take your word for it. Anytime I see, and I'm not saying you're guilty, but
Yeah.
anytime I see a fentanyl case, I'm concerned. So I always make inquiries about that. So I hope you use your good judgment from this point forward. What do you want to set in this case? What's the negotiation day?
Negotiation day,
What's the negotiation?
February 13th.
February 13th at 9 a.m. You be here February 13th at 9 a.m. for negotiation. Next court date, February 26th. Both of them are conditions of your bond.
Okay.
Where do you live?
I'm in Virginia,
You are.
but I've been staying in Kentucky for the trial, you know, so. I mean, whenever I wanted out of jail, that was.
Were you just, I don't, give me names or details. We're just visiting somebody here, or we're just passing through, or what's the deal?
Well, I was just passing through whenever I got arrested, so.
Well, welcome to Cumberland County.
Judge, do you think there's any way we might work this out today, or would you be in a position to do that, Mr. Stock?
Not really, but I have no objection to her going back to Virginia as long as she's here. It's pretty cool.
I'll be here. I don't,
Do you want to go to Virginia? You want to go back home, or you
I
want to stay
mean,
here?
that's the plan. Like, I want to go back home. Let's go back to my parents' house, so.
But she'll sign a waiver of extradition.
Sign a waiver of extradition, so we won't have to go over there and get,
I understand.
dog the bounty hunter to look you up or something like that.
And she signed before, that was the condition. Yeah, I signed that already.
Okay.
Yeah. It's in the file. Sorry.
Well, you just want to, can you Zoom her on the 13th?
Yeah, I don't cheat as long as she's
Oh.
contact Mr. Sheffield.
Okay, here's what we're gonna do. We'll give, do you do Zoom on these negotiations? Will you just keep in contact with Mr. Sheffield on the 13th
Okay,
and be available to negotiate with him on that day? And that way you'll just have to come back here one more time.
okay.
Okay.
I had a question,
You better ask him first.
Yeah, that may end up, that's what we're gonna talk about on the 13th.
Okay, okay.
That's what resolutions might look like.
Okay, just making sure.
Okay. Well, you be in contact with him and I'm not gonna require you to come back to the 13th.
Thank you.
So you, if you reach an agreement and resolve the situation, you come back 26th, enter a plea or set a trial date. Okay?
Thank you.
Be on your way rejoicing and take care not to get back into this. thing.
Oh, I know.
Okay,
Trust
thank
me.
you very much.
Thank you. I appreciate it.
Yeah. April Nedry. Commonwealth versus April Nedry, 25 CR 0072 and 25 CR 0073. You are April Nedry. You were born in 1981.
Yes, sir.
Last four digits of your social security at 5139. You're here for arraignment. You're represented by the Office of Public Advocacy. Is that right? Yeah, we'll continue that representation. The grand jury of Cumberland County is returning an indictment charging you with traffic controlled substance first degree first offense. Traffic controlled substance first degree first offense. You understand what those charges are?
Yes, sir.
Okay. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions. You do that? Yes. Enter a plea of not guilty, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
Yes, sir.
Okay, you want to set a negotiation day for the 13th and next court?
My understanding is there's gonna be another case coming and we're probably gonna be seeking conflict counsel on this. I think we're already in the process.
I think it's a possession case or something.
Well, we can still set her for the 13th.
We can, and whoever the attorney is, we can send them the information.
Yeah,
And I have no objection to her staying out on the same bonds, that's all right. So,
okay, so conflict counsel be on the new case or on this case?
I'd say all three cases.
Whatever she got.
So the new conflict counsel will be handling all three of the new case, these two in the other new case.
Right.
Okay, well, you make sure, let's give her 10 days to get conflict counsel. Think y'all can get her conflict counsel by then?
I think we're already in the process.
Okay, so the conflict counsel will be here on February 13th at 9 AM for negotiation and the 26th. And remind me if that indictment comes out today, to issue a summons on it, so we won't have her rearrested. Okay, so we'll do a summons on the new indictment. Okay. Ricky Purdue. Are you Ricky Purdue?
Yes, sir.
Good morning.
Good morning.
You're here on 25 CR 0067 for a pretrial conference. What does the Commonwealth have to say?
Your Honor, we're still waiting on the lab report on the blood test.
You were born in 1981, last four digits, social security number 1284.
Yes, sir.
Okay, how long has it been gone?
It's been going a while. It should be back in time.
Okay, let's schedule for a negotiation day on February the 13th and next court date on the 26th. And if it's not back by the 13th, council can get a hold of each other, okay? You got those two dates down there?
Yes, sir.
Okay, thank you. Caitlin Riddle,
We put her in CIC, Your Honor.
Bernice Stearns. Bernice Stearns.
I think she may be one of the ones, no.
She might be in drug, I don't know if she's in drug court.
She's what?
I have been allowed her to come out on her anything. She's kind of.
Where is she in treatment at?
Gosh, I can't remember, Jim. Go.
Where is that located?
Somerset, Your Honor.
You don't have a number for it.
I said.
You have a number for them when she's back.
We've called a case of Commonwealth of Kentucky versus Bernice Stearns. Is Sky Hope on there today? Are you on the Zoom link anywhere? Well, I don't know why they're not here.
Hello,
Hello,
this is Rebecca.
Oh,
okay.
Thompson.
Well, we hadn't called your case yet, but we will. She at the same place?
yeah.
Is Bernice Stearns there also, you know?
Yes,
Could you have, before we finish with you, could you have them send for Bernice too? Can you do that?
okay. You want me to get her now?
Well, let's do you, we're gonna go ahead and tell them to bring her on in too. We'll get both of them.
Okay. Right now? Well, me and both.
Okay, let's do Bernice first here. Commonwealth versus Bernice Stearns, 25 CR 0068. You are Bernice Stearns.
Yes, sir.
You were born in 1982.
Yes, sir.
Last four digits of your social security number are 0513.
Yes,
You're
sir.
here for sentencing today. Have they gone over this pre-sentence investigation report with you yet?
Judge, I didn't know where she was at.
Okay, well, we didn't know where you were at. How long are you scheduled to be there, Bernice?
I should have about, I should come out of here in like end of March, 1st of April.
Okay, well, what I'm gonna do is, schedule your sentencing in March 24th. And your
Okay.
your attorney will go over and go over this pre-sentence investigation report. If you leave there anytime before that, you either dismissed or you leave voluntarily, you must immediately contact your attorney and talk to the Commonwealth Attorney's Office to see if we want you incarcerated until your sentencing, okay?
Okay, I wasn't aware I had to be in court today. I thought we'd done settled.
You're all right. Don't worry about it.
Okay,
Your attorney has said he didn't know where you were. Now he does, and we'll take care of this, okay? You just work on getting yourself straightened up, all right?
okay, thank you.
Okay. Now, now let's go to Rebecca Thompson.
I'm here.
Rebecca, we're here on 25 CR 0074, probation application. Were you born in 1980?
Yes, sir.
That's 4 digits of social security number 9406.
Yes, sir.
Okay, what's the Commonwealth have in this case?
Yeah, the Commonwealth filed a motion to revoke because of positive test. She met with Mr. Garner and they had her placed at Sky Hope, and we just asked to continue our motion generally to see if she completes
Mr.
rehab.
Garner, is that your suggestion?
It is, Your Honor.
Okay, the probation and parole officer says that they're satisfied with the progress that you're making, that you're over there in that treatment. And so they're going to continue the motion to revoke to see if you continue to do well.
Okay,
If you leave there for any purpose, you need to call the probation and parole office immediately.
okay,
We'll make the decision on whether you need to be incarcerated or what the deal is. So you keep on working on the thing, okay?
okay.
Okay, thank you very much.
Thank you.
Cody Stinson.
He was still in the hospital. Here they are now.
Give me an update where I can hear you there.
As far as I know, he's still in the hospital at U of L. They were
Those
supposed
are
to,
operative words in this case, aren't they, as far as we know?
well, they were supposed to call me upon release or when he was getting ready to be released, and I hadn't heard anything from him.
They just brought this up, Penny. I'm not ready.
Give it to you.
So I guess they communicate with parts to me. Well, that's the same update I got about a month ago.
And it says his condition is,
Yeah, he's, without going into that, he's being treated. And the last time I spoke with him up there, there was some hope on his prognosis that, but I don't know how that's going now.
didn't we hear that, was it last time they thought he might be transferred to a different sort of facility or
For
something?
maybe some type of rehab facility, but he's still at U of L hospital.
We don't know whether would it be possible to get somebody from probation and parole up there to go take a look at him to see if he's coherent? What would be the appropriate agency?
Well, the PSI has never been done, and I don't know if the sex offender, Miss Thompson would probably know if the sex offender person has ever visited him or not. I know she went one time and he was unresponsive. But somebody, you would think somebody local probation officer could go check in on.
I can inquire, Your Honor, I can ask a local office. I can't guarantee if that supervisor of that district will comply with me, but I can make the request, Your Honor.
If you'll make a request or do that, and if they don't want to do it, I'll call one of my fellow circuit judges up there and see if they can convince them to go over there and take a look.
Last time I spoke with Louisville Metro and they sent an officer over there and confirmed he was there, but that's all they would tell me because of the HIPAA that he was just
Yeah.
there.
Okay, thank you very much. Joshua Vibert. Commonwealth versus Joshua Vibert. 22 CR 0021 and 22 CR 0069. You born in 1982?
Yes, sir.
And last 4 digits social security number is 669.
Yes, sir.
What we got here today?
I come to see if you give me permission to go on a cruise with my wife and child. I'm on probation and I have to have your permission, the course
What do
permission.
y'all say?
Your Honor, Mr. Rivers on unsupervised probation. On unsupervised probation, he doesn't have to have permission to leave the state anymore while on probation. However, he's leaving the country into international waters. Therefore, we probation patrol cannot give him permission to leave the country. He'd have to have the permission of the court.
How's he doing on probation?
He's on inactive. He's done well. I have no complaints about him.
Bon voyage. That's all I can say.
Do I need something other, because I don't want to get in trouble. Do I need
You're
something
not gonna get in
signed?
trouble. I'm the one that would put you in trouble, and I just tell you, have a happy sale here. We'll get it. Could y'all draft an order up? Is there a form or something?
Hey, that'd be a great order, Your Honor.
Yeah, we'll send you an order. Yeah.
Thank you.
Now, don't feel obligated to bring me any souvenirs or anything. It's not a quid pro quo, but you, enjoy the time with your child and you just think about how you could have missed all that if things had gone differently. You know what I mean? Okay, see you now.
Thank you.
Yeah. Bobby Garman. Caldwell versus Bobby Garman, 25 CR 0051 and 25 CR 0055. Are you Bobby Garman?
Yes, sir.
You born in 2001, last four digits, social security number 1566.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
No, Judge, I think you were down in drug court.
yeah.
So he was down in drug court and just came in a minute ago, so he does need to look at it real quick. I'll point out the high water mark.
Okay, we'll come back to him. Robert Kelly for sentencing. Are you Robert Kelly?
Yes, sir.
Good morning. We're here on 25 CR 0070 for sentencing. Were you born in 1977?
Yes.
With the last four digits, social security number 4514.
Yep.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
It's the same thing. I think he just got here from downstairs.
When did you get these PSIs to go over with them? It's just, you're just getting back in this thing here.
I got these a couple of weeks ago, which allowed me to talk to the people in jail, but I didn't have any contact with these folks. We're getting you thanks for headed on there.
Yeah, I'll come back to those. That finishes the out of custody here.
There's two up here that they're on the jail docket.
Which, are they on the Dare County Jail docket? Who are they?
I think I ain't this docket.
Okay, bring Matthew Day out. For sentencing. I don't know if we're going to sentence anybody there or not. Commonwealth, Kentucky versus Matthew Day, 25 CR 0069. Are you Matthew Day?
Sir.
Good morning.
Morning.
Were you born in 1987?
Sir.
Last four digits, social security number 6558.
Sir.
You're here for sentencing. Have you had an opportunity to go over the pre-sentence investigation report?
Judge, we have no substantive errors to
Everything's
report on.
substantially correct. Is there any reason why you should not be sentenced today?
No, Judge, I am curious to hear, did you get released this morning?
I gotta go back down there and meet with him.
Okay.
Upon pleading guilty, possession of controlled substance, first degree, second offense, defendant shall receive a sentence of 3 years, probated for 5 years to be supervised on plea of guilty, operating a motor vehicle under influence. You should pay a fine of $200. Then it should, what are the total fine and court costs?
$855.
$855. Now, you understand when you entered that plea that the possession was a felony and the DUI is enhanceable too. Both of them, if you get a repeat on either one of them, could be enhanced. You understand that?
Sir.
Total amount is, and we have the DUI paperwork turned in. Total was what?
$855.
$855. I'll let you pay that at $75 a month, starting 30 days today, so you get back on your feet a little bit, okay? Okay. Okay. Okay, thank you. The other one back there is who? Mary Beth Stalker. For sentencing. Commonwealth versus Mary Beth Stalker. 25 CR 0078. You are Mary Beth Stalker. You born in 1983.
Yes, sir.
Last four digits, social security number 4920. Have you had an opportunity to look at the pre-sentence investigation report number probation parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason why this lady should not be sentenced today?
No, Your Honor. I'm representing her, Ms. Stalkup, today.
On plea of guilty possession of controlled substance. First degree methamphetamine shall receive a sentence of 2.5 years. Sentence shall run consecutively to Cumberland Circuit Court 23 CR 0038. A 5-year sentence for a total of 7.5 years, probated for 5 years, supervised. Now, are you in the specialty court? You've been accepted in the specialty court.
Yes, sir.
Okay, you be released, is it?
She's on a hold through specialty court. I had to leave this morning before her case disposed of, but she's not started with.
Okay, we'll put a hold on. What are the court costs involved? $245. I'll say that you pay that $50 a month starting 60 days from today. We'll know more about what's going on in our court. Now, I'm not going to inquire as to why you hadn't gotten off to a good start. But I will just tell you this. I've known you for a long time, known your family for a long time, but you've got 1 foot in the penitentiary and 1 on a banana peel. You got to stop this. You got to stop it. You give an opportunity to work with you in drug court.
Yes, sir.
So there'll be no misunderstanding when you come back. It's not, I don't have anything personal against you. You understand what I'm saying?
Yes, sir.
Okay, thank you very much.
Your Honor, that's all I have. May I be
Yeah.
excused?
Absolutely, yes.
Thank you.
Okay, we're supposed to go to Monroe County in 15 minutes. Monroe County, are you on there now? Is Eastern Kentucky Correctional Complex on there? Paul Bricker. Is the Little Sandy Correctional Complex, are you on there? Okay, I'll call the diversion completion document, docket rather. Jean Parham. And Cheryl Prophet. Okay, we'll enter those 2 orders under the motion.
Judge, Mr. Garment is ready to proceed after reviewing this.
Pardon?
Mr. Garment, Bobby Garment.
On sentencing, is there an opportunity to look at it?
Yes, sir.
Little Sandy, we will be with you next, okay? Okay, this is Commonwealth Kentucky versus Bobby Garman. We've previously identified Mr. Garman. This is two cases, 25 CR 0051 and 25 CR 0055. Now, you asked for a time to review the pre-sentence investigation report. Is it substantially correct?
Yes.
Okay, upon plea of guilty to indictment number 25 CR 66 for theft for lawful taking disposition, and it shall receive a sentence of 10 years. Upon plea of guilty to indictment number 25 CR 0051 for theft of deception, 5 years. The 10-year sentence and the 5-year sentence shall run consecutively for a total of 10, concurrently for a total of 10 years. Now, Mr. Stockton.
Yeah.
Let's go back to this case a little bit. Was this the automobile?
Now, Mr. Garment had a concrete business. and he pled guilty. Two different cases where he took potential customers' money and either no work or very little work was performed.
Okay.
Now, he has two other cases pending, I think in Barron County and Graves County. Grace. And I don't know what the disposition of those is. I'm hoping they'll probation so you can stay in the
They have this, you know, so I don't know what Grace is.
Okay.
The defendant shall pay, they should be probated for 5 years supervised. Now, is it appropriate for the probationary period to be until the restitution is paid?
I would think so, because it's about what, $20-some thousand here.
16,000 and something else, so I'm gonna add in 4,000, so I'm gonna make the probationary period. Modify the judgment, the probationary period shall last until the at least 5 years, but at most until it's paid, okay? So it should be at least 5 years, but until, and thereafter until it's paid. The restitution amounts are set out $16,000 and $4,000 to $150 a month on each total restitution $300. What are the court costs?
It's $190 on each case.
$190, so I'm gonna merge those two cases, say $190, and you add additional $30 a month to the payments of the court costs. Did you go into the specialty court here?
Yeah.
Is that going okay?
I just started today.
Started today, well, you hadn't messed up yet. then.
No.
Okay, well, you need to meet with the probation and parole officer there. Okay, let's go to Little Sandy Correctional Complex via Zoom. Commonwealth versus Scott Barlow, 25 CR 0016. You are Scott Barlow,
Yes, Your Honor.
born 1971.
Yes, Your Honor.
Last 4 digits, social security number 1542. What's the Commonwealth have to say on a motion for shock?
Commonwealth opposes shock probation, Your Honor. This is a case where he had a 10-year sentence. He had a PFO. He took Jeff Mauer's utility trailer, took it to Indiana, had about $40,000 worth of tools on it. And the trailer was recovered within 24 hours, but all the tools and personal property was gone. Unless he's got the ability to make restitution, Commonwealth's opposed, and we're not wanting payments either. The victim's not.
Judge, I believe this was filed by my predecessor. I will note that they did wait until virtually the end of the statutory period. So he did serve as much time as almost he possibly could before.
Have you talked, you had an opportunity to talk to this gentleman?
No, I've talked to Mr. Stockton about it, and obviously Commonwealth is concerned about restitution payments.
Well, the victims are, and I'm relaying the victims' concerns.
Well, I mean,
Yeah.
that's fine.
Yeah.
Is he?
You want an opportunity to talk to this gentleman before I rule on it?
Is he, where's he at?
Little Sandy.
Okay. Well, I mean, if there's any chance that he could meet,
Well, you need to talk to him.
meet
about it.
some condition of the Commonwealth, that might be.
Right, so I'm not gonna rule on this today. I'm gonna give you an opportunity to talk to this gentleman, person to person, to see if there's any possibility of any restitution agreement that might impact my decision on
Well, I
this.
know the victims, the defendant's mother has reached out in some third-party way to the victims, saying that she could pay some money and then make payments, but I don't think that was satisfactory. So I don't know if he has any other
Okay,
resources or
well,
not.
this needs to be formalized,
That's
not back
correct.
channeled.
Yeah.
So if your mother or someone else is trying to help you, she needs to call your attorney, and the attorney will meet with you and see if y'all can work something out, okay? So I'll take this under advisement. Little Sandy, thanks for your cooperation. Y'all are excused.
Thank you.
Yeah. Is Eastern Kentucky Correctional Complex on the line? Barron County Detention Center, are you on the line? Barron County Detention Center, evidently not. Okay, we have one other person. We have Robert Kelly for sentencing. Is he?
Yes.
He should be ready. Commonwealth of Kentucky versus Robert Kelly. Twenty-five CR 007. Mr. Kelly, we already identified you a few minutes ago, I believe. Have you had an opportunity to look at the pre-sentence investigation report on probation and parole?
Yeah.
Is it substantially correct?
Yeah.
Upon a plea of guilty to possession of controlled substance, first degree methamphetamine, he is receiving 3 years. Sentence shall run consecutively. Circuit Court case number 20 CR 64. 3-year sentence for a total of 6 years. Probated for 5 years. Probation should be supervised. The defendant agrees to continue his probation for 5 years in case number 20 CR 0064. He shall enter and complete the Cumberland Specialty Court program. Obtain gainful employment. What are the court costs?
The court cost was $185 and she had assessed him a $750 PA fee. So both of those together is $935.
$935. So you need to be paying those. Can you pay $90 a month? Is that gonna push you?
Right.
Well, no, if it's gonna push you, get back to 60 be better.
Yes, they should be better.
Okay, I'll do $60 a month and the first payment will be done in 30 days. Okay, work hard in that specialty program, okay? That takes care of the live docket. Okay, Monroe County, are you on there yet? Eastern Kentucky, are you on there yet? If not, we'll go to the Dare County Regional Jail. Adair County, are you on there?
Yes, Your Honor.
Timothy Alexander. Are you Timothy Alexander?
Yes, sir.
Good morning. You're here on 23 CR 0039 probation revocation. 25 CR 0086 an arraignment. Were you born in 1982?
Yes, sir.
Last 4 digits social security number 5227. You
Yes, sir.
represented by the Office of Public Advocacy. You want to
Yes,
come
sir.
forward, counsel? Yes, sir. On Timothy Alexander. Mr. Alexander, you have the right to remain silent. This is your lawyer here. He's online. He's here in courtroom. The grand jury of Cumberland County has returned an indictment charging you with burglary in the 2nd degree. You understand what that charge is. I'm not asking you whether you did it or not. You understand what the charge is?
Yes, sir.
Counselor, do you acknowledge the identity client received indictment, away formal reading arraignment, interplea of not guilty, preserving all pre-trial motions?
Yes, Your Honor.
And we'll set a negotiation date for February 13th. And next court appearance is 26th February. I'm gonna sign a reciprocal agreement. We'll do the negotiation date will include negotiations about the revocation. And I'm signing a reciprocal discovery order that requires the Commonwealth to provide you information so you can prepare your defense. Okay, thank you very much, Mr. Johnson.
Thank you.
Your attorney will be up to see. Jason Bailey.
Bailey.
Are you Jason Bailey?
Yes, Your Honor.
Morning, this is 21 CR 0020, a probation revocation. Mr. Bailey, were you born in 1977?
Yes, sir.
Last 4 digits, social security number 9002.
Yes, sir.
What's the Commonwealth have to say?
Your Honor, we have two motions. There's a motion to revoke probation, and there's also a motion to forfeit a vehicle that's been held by the Cumberland County Sheriff. I think since this case has been going for the last 3 or 4 years, we didn't know it was over there. So that's the two motions we have. And basically, the motion to revocation is he was being supervised by Tennessee, the state of Tennessee, through ICOTS. And according to them, that last contact they had with him was in April, then they tried, of 24. Then they tried to contact him again in November and they couldn't find him. And so they sent a request to Mr. Garner, I think, to have him revoked, that they could no longer supervise.
What do you say on behalf of the defendant?
Judge, I have met with Mr. Bailey, so I do have some insight. And, you know, we don't dispute, the lack of reporting, that the Commonwealth has communicated. I will note that there were no charges that I'm aware of or that the Commonwealth made me aware of that have been picked up in the
You need
meantime.
to speak up just a bit.
I would note there's no charges. He hasn't picked up any new charges in that time. Obviously, that's not all you're supposed to do on probation. So I would ask the court to consider that when making its decision whether to revoke.
Our problem is through ICOTS, their hands are tied because if the court doesn't revoke him, Tennessee did a mandatory retake, they will not take him back to supervise him. So.
Well, I'm gonna revoke his probation. And we have an opportunity to look at shock probation sometime down the road on him. If you find more detail about what this gentleman is gonna do and whether he'd be subject to supervision in Kentucky, does he have any restitution or anything that's coming in this
No,
case?
this was a drug case, Your Honor. There's no restitution.
Okay, well,
Your Honor, can I speak?
at your own peril, you don't have to. Go ahead.
Your Honor, I had a $240 fine that I owed, but it's paid. So I don't owe no fines or nothing like that.
Yeah, well, the problem is you absconded from supervision. You need to talk to your attorney about, that and not here because you might say something to damage you. And I'm going to consider a shock probation motion once he gets fully informed and can present it back to me, okay? I don't think that y'all are prepared to argue that today. Is that right, Counselor?
Well, no, I mean, today's just a revocation.
Yeah, so he'll come and talk to you and you'll tell him what your plan is. They won't take you back under supervision in Tennessee. So you'll need to formulate a plan and present it to Commonwealth. We could very well shock probation, okay? But.
Thank you, Your Honor.
Okay, thank you very much.
And I guess there's no opposition to the forfeiture motion.
Is there any opposition to the forfeiture of the vehicle that's been up here? The rental of the vehicle would consume its value, right? What kind of vehicle is it?
I'd have to let me look. So it's a 2010 Chevrolet HHR. Is that your vehicle or Mr. Harris's?
No, it's not my vehicle.
Okay, well, he wouldn't have any interest in it anyway. We'll check on the ownership on it.
Okay, thank you very much. Your attorney will be up to see you.
All right.
William
Thank-
Brooks. Yeah, thank you.
Brooks.
William Brooks.
Yes, sir.
Commonwealth versus William Brooks. 25 CR 005 and 25 CR 006. Are you William Brooks?
Yes, sir.
Born in 1983.
Yes, sir.
Sported at Social Security number 7291.
Yes, sir.
Here today for sentencing. Have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
You had a 5-year sentence diverted, which was revoked, and a 1-year sentence to run with that on a plea. Is that going to be consecutively, Mr. Stockton?
I'm sorry, Your Honor.
Is that going to be consecutively? 5 and 1?
I
Yeah,
believe so.
diversion revocation,
Yeah, it'd be 6 years total.
6 years total. Is that correct, Counselor?
I believe that was my understanding as
Okay.
well as Mr. Brooks.
Okay, I'll enter the order sentencing you to 6 years. Barry Gibson. Barry Gibson. For sentencing.
Good morning, Your Honor.
Good morning. Are you Barry Gibson?
Yes, sir.
This is 22 CR 0037. Mr. Gibson, were you born in 1969?
Yes, sir.
That's 4 digits, Social Security number 9632.
Yes, sir.
Okay, you're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report number probation parole?
Yes, sir.
Okay. Is it substantially correct?
Yes, sir.
You had a 3-year pretrial diversion that was voided on December 15th. And 5-year pretrial diversion that was also voided rather on December 15th. That's 8 years. Are those to be concurrent or consecutive, Mr. Stockton?
Yes, 5 years total, I believe.
Okay, I will send it to you to 5 years. 5 and 3 and just combine them into 5, okay? Thank you very much. Holly.
Yes, sir.
Hannah Holly. Hannah Holly. Are you Hannah Holly?
Yes, sir.
Good morning. We're on 25 CR 0038. Were you born in 1997?
Yes, sir.
Last 4 digits, social security number 8595.
Yes, sir.
We're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, I don't know if Justin Buszczyk's on the line. I believe that's how you pronounce his name. She's on a motion to revoke and impose sentence on a pretrial diversion. And last contact I think he had with her was around November 13th of 25, and he listed her as abscond. There he is. I think Mr. Buszczyk's on there.
I'm Officer Smith. I'm filling in for Officer Buchek.
Okay.
Okay. Are y'all going to stipulate to this or do you want?
Judge, she was, may I approach? I just didn't want the whole courtroom necessarily hear what I'm.
We'll talk to the Commonwealth about this. Let's go. Are we broadcasting this? So I'm not.
You gotta shut off. Oh, Zoom.
Should come over here and do it, please. Right here.
Yes.
Okay, this lady's attorney has requested the opportunity to talk with her more about her situation a little bit. So we're going to set a negotiation day up on February the 13th. We need a transportation order for her on that date. And then the next court date's February the 26th. Rather than do that, an officer will recognize you to be back here or whoever you're representing on February the 26th. You can call and get a Zoom link for that. Okay?
Yes, sir. Yes, sir.
Thank you very much. Aaron Lee.
I'll explain everything after we're done.
Aaron Lee.
He's coming, Judge.
Okay. Are you Aaron Lee?
Yes.
Good morning. This is 25 CR 0077, a pretrial conference, and also 25 F 0066, which is an arraignment. Well, I would assume that we're going to do this by information. Is that right?
That's correct, Judge.
I don't have that.
Yeah, I'll come talk to you when we're done.
Need the information. Yeah. Yeah. Okay, in addition to that, we have 26 CR 002, which was previously district court case number 25 F 0066, which is an information which says that on or about the 26th day of November, defendant committed the offense of possession of controlled substance. And by agreement, It's appearing now by information in the Cumberland Circuit Court. Is that correct, Counselor?
Yes, Judge.
And do y'all have a plea agreement? We need copies of this, make some judge. Do what? Copies. You acknowledge the identity of the client, receipt of the information, waveform reading arrangements.
Yes, Your Honor.
So both of these can be considered. A motion's been tendered, sir, that says you wish to enter plea guilty today. Is that correct?
Yeah.
Are you under the influence of drugs or alcohol now?
No.
Is plea freely and voluntarily given?
Yeah.
Are you the same person named in indictment number 25 CR 0077 and information number 26 CR 002?
Yeah.
Is your judgment prepared today in any way?
No.
You discuss these charges with your attorney and you're satisfied with his advice.
Yeah.
View the evidence the Commonwealth has against you, you believe you're fully informed about your case.
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go down through them and then ask you if you do, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, to be represented by counsel at your jury trial, to confront and cross-examine all witnesses called to testify against you. Produce evidence, call witnesses in favor to appeal this matter to higher court if you lose, and require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes.
Now, I consider the Commonwealth's recommendation, but I make plain range of sentence provided law. I don't have to accept the recommendation. If I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea guilty and proceed to trial. You understand that?
Yes.
Okay, now I'm gonna ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No.
Do you have any felony convictions in the past 10 years?
No.
Are you currently on probation or pretrial diversion?
No.
You understand that if you successfully complete the diversion, the charges will be dismissed pre-trial diverted, and you'll have an opportunity to have your record expunged. You understand that?
Yes.
You understand if you do not successfully complete the program brought back in front of me and I avoid the pre-trial diversion, schedule a hearing and sentencing, you'll be a convicted felon that could be used against you in the future. You understand that?
Yes.
Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance, first degree methamphetamine in case number CR or 25 CR 77, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to possession of controlled substance, first degree methamphetamine in case number 26 CR, whatever the new case, what is that? And 2, oh yeah, 26 CR 2, the defendant shall receive a sentence of 2.5 years. These two sentences are to run consecutively for a total of 5 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall enroll and complete a long-term rehabilitation to be chosen by DPA and approved by the Commonwealth. The defendant shall not be released until a bed date is available and must go directly into long-term treatment. The defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Is that what you agreed to, sir?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
Do so of your own free will.
Yeah.
Knowing your constitutional rights, it's to your desire to proceed, allow the court to fix your punishment. Okay, now bring the document up here and let me show him his signature, please. That's your signature on there.
Yes.
And Mr. Stockton, you need to sign these too, though. Thank you, signing. I'll accept the agreement and sign the version. Or what are the court costs in this case? $215. I'm gonna allow you to pay that at $50 a month. First payment 30 days after your release from jail, okay? Now, when will he need to meet with probation parole?
Upon release from his facility, Your Honor.
When will that be? Today?
6 months after he gets, he'll get out 6 months from the rehab. Have to report back to me.
So you gonna wait till he gets out of the rehab to meet with you?
He'll be supervised if like that.
Yeah, I'm gonna schedule him to be transferred to, officer closer. That will supervise him while he's at the facility.
That officer will go meet with him then?
Yes.
Okay, we'll go ahead and allow you to be transferred when the agreed order is sent down and the probation parole officer will come meet with you at the facility, okay? Okay, thank you very much. Austin New.
Hang on, let's see.
Commonwealth, Kentucky versus Austin New, 24 CR 0032, 24 CR 0033. You are Austin New,
Yes, Your Honor.
born in 1986,
Yes, sir.
4 digits social security number 8512 110 rather. This is a motion for a trial date. Is counsel on the line here?
Let's see Mr. Farr's name there.
Counsel, you want to turn your camera on? Mr. Farr? Mr. Farr, are you on? I see you're on there. Will you turn your camera on?
Veterans living off. I don't want to come for our county today. I would Google it very fast. There it is.
You need to turn your microphone on, Mr. Farr.
Sorry, Judge, stepped away and took a call. Sean Farr for Mr. New.
Okay, it's a motion to set a trial date. Is Commonwealth ready to go to trial in this case?
We are, Your Honor. It's our hope that the trial can be scheduled around the victim's calendar to some extent. She's in college right now,
Okay, let's look at the calendar.
and she will get out about the first week of May, at the end of that first week. And I would say sometime between the middle of May through July the 12th, or from about
It's a
July.
2-day trial.
I would think so, yes, because of the video evidence.
And Judge, we had, we agree and we had thrown around some dates, maybe even with your calendar there. And I just had some tough ones. I've got a murder trial expected to go a couple weeks. That's right there at the end of May. And then I've got kind of a bad one right there at the end of June and in the middle of June. So I'm flexible there. We just kind of couldn't pin down specific days, Your Honor. That didn't look like a real hairy conflict.
And Your Honor, if those dates don't work, probably between August the 2nd and August the 17th would be all right. You want to go into August.
That gets into the fall calendar though.
Well, that's the reason I've got her schedule. I've got the young lady's schedule.
You go that far, Judge,
School
and then
starts on
I
August 17th.
don't have any problems.
Well, I think this case needs to be tried. He's up there at the expense of the Cumberland County, you
The
know.
only thing I'd ask is we try it after May because we got O'Donnell coming up
That's
anyway.
right. That's right. What about June 1st, 2nd?
That's fine with Commonwealth.
I'm sorry, Judge, what was the date?
June 1st, 2nd, and 3rd.
Judge, I cannot take that date and I apologize. I've got a trial that begins kind of that preceding week in Spencer County that is about as locked to go as they come. I'll admit, Judge, I could probably work around this for the remainder of June. Um, and go to these other counties and without a custody defendants and move them.
So you can go with the 1st, 2nd, and 3rd? Did you
No, I
say?
think he's saying later in June, I believe.
Later in June, you're talking
Yeah,
about?
yes, Judge, I am set, but
Okay, wait just a
I'll
second.
move them.
Wait just a second. Twenty-second, 23rd, and 24th of June.
That'd be fine, Your Honor.
That'd be fine, Judge. Right after Father's Day, that's,
Well, just don't make any comments about that in this case.
yes, Judge.
I'll be scheduling all 3 days.
All three, we're reserving all 3 days. Now, any pretrial motions that need to be filed in this or motions to exclude or anything need to be filed by May the 28th. Okay, and that needs to be included in the order. Okay, thank you very much.
Understood, Judge. Thank you.
Thomas O'Donnell.
Good morning, Judge.
Good morning.
Good morning, Judge.
Morning. Commonwealth versus Thomas O'Donnell. 22 CR 00103. Mr. O'Donnell is present. His year of birth is 1961. Last 4 digits, social security number 6773. We have a motion to secure attendance.
Yeah, that's our motion for out-of-state witness, Your Honor.
Is there any objection to that on behalf of the defendant? Okay, and then you have a motion to reconsider. You want to state that?
Yes, Your Honor, if I may be heard on that motion. That motion was a request to reconsider or primarily for the court to go ahead and dismiss the enhanced penalties that had been noticed based on the information that has been submitted. So, Judge, this remedy that we're asking for is a narrow remedy that's grounded in fairness. So this case involves a government intrusion into clearly marked attorney-client privileged legal materials. And those exhibits have been submitted previously and reattached to this motion. It's undisputed that jail staff opened and went into these materials, which contained defense notes and strategy. It's also undisputed that case-related.
I don't know that that's undisputed or not. Come up to the podium. It's undisputed that the jail people searched some of his papers.
It's undisputed that his notebook was searched.
His search, but
It's
the Commonwealth
disputed.
says that you don't know what was in it.
We don't know what was in it. State police investigated the matter. There was nothing of any significance reported to them that the jail staff saw. So if the jail staff was trying this case, I think they might have a valid argument, but the Commonwealth or the Commonwealth's agents is going to be witnesses in this trial do not have any access to any
So I don't know how I
privileged
can
material.
restrict. I've already ruled on this. We've had a long argument on it. How can I restrict what I do not know existed in which the Commonwealth says it has no knowledge of it? Now, what do you want me to specifically restrict?
Judge, and this isn't an issue as to whether these materials
Answer the question that I posed to you, please. What do you want me to restrict?
the availability of enhanced penalties.
Well, I'm not going to restrict the availability of enhanced penalties on something that is not going to be used the Commonwealth says they have no knowledge of it. So I'm overruling your motion. Okay, is there
And
anything
Judge,
else?
may I just finish making a record of the motion, even if the court
Surely.
is, okay, thank you. Judge, these members from the jail were interviewed, such as Christy. And in this interview with police, she communicated some of the case-related information that had been ascertained from these materials. And again, these were materials that were clearly marked as legal materials. We know that pretrial incarceration does not diminish the attorney-client privilege. Kentucky law expressly protects confidential legal materials. Again, those materials were marked, and it's unfair to say that case-related information was not communicated from those books, because we know case-related information was communicated to Mr. Wright with the Commonwealth's Attorney's Office, and we know that case-related information was communicated to Mr. Stockton.
Could you be more specific?
You want to be more specific?
I don't know what you're referring to.
The Commonwealth says it's not aware of what you're talking.
And Judge, that's the issue. I don't want to diminish the privilege further by now relaying this confidential.
I've had all of this argument that I want to hear. You're asking me to reduce the charges or possible penalties against your client upon a thin gruel, a thin soup that's made out of as Abraham Lincoln said, it's made out of a shadow of a crow that starved to death. I don't know what you're talking about. The Commonwealth says they have no information that they received. And I'm not going to diminish the serious charges against your client predicated on something that might have been seen that I don't even know would affect your defense in this case. So I don't have enough information. And if I did have enough information, the only thing I could do would order the Commonwealth not to use any information or any fruit thereof. And that's a different remedy than you're requesting. Your remedy is out of proportion with the allegations you made, in my opinion, and that's the ruling. Okay? Thank you very much. Is there anything else anybody has on this case?
Not today, Judge.
Thank you.
Your Honor, I've got to be in Woodford County at 1 o'clock.
You have a case on the docket?
Yeah, Elizabeth Watson is all we have.
Okay, I'll call Elizabeth Watson.
Thank
Elizabeth Watson.
Watson.
Commonwealth versus Elizabeth Watson, 24 CR 0086. Excuse me a second. Excuse me. Are you Elizabeth Watson?
Yes, sir.
Were you born in 1970?
I was.
870?
Yes, sir.
Is that correct?
Yes, sir.
Last 4 digits, so number 8925.
Yes, sir.
Probation revocation motion.
You ready for proof, Your Honor?
Yeah.
Your Honor, we will stipulate the violation. This is.
Well, I want to know what it is anyway, so.
I'd let Officer Garner explain.
You raise your right hand. Swear the testimony about to give us the truth, whole truth, nothing but the truth.
Yes, Your Honor.
Okay, go ahead.
Officer Garner, can you tell us about the events that occurred on December 23rd and 24th of 25? The result of Mr. Watson currently being incarcerated.
On 12/23/25, Ms. Watson reported to the Columbia Office of Probation and Parole for the purpose of monthly reporting, making up the missed report day while incarcerated on her sanction. In this officer's experience and training, Ms. Watson's demeanor and actions were consistent with recent substance abuse use. Ms. Watson was given urinalysis and was on-site positive for, admitted to, and signed admission of guilt form for the use of methamphetamine occurring on or about 12/20/25 while incarcerated. It appears Ms. Watson was attempting to manipulate officers by deceptive behavior, false statements, and providing an initial sample that was flagged on the tamper indicator of the urinalysis cup and did not register a temperature. On 12/24, Ms. Watson reported to the Columbia Office of Probation and Parole for the purpose of making up the urinalysis. Ms. Watson was given urinalysis and was on-site positive for, admitted to, and signed admission of guilt form of use of methamphetamine occurring on or about 12/21 after being released from jail. On 12/23/25, Ms. Officer Burton assisted in giving Ms. Watson urinalysis, whereas Ms. Watson provided a sample that was off in color, neon green, chemical green. That the tamper indicator on the side of the cup produced a color identifying the sample had been altered. The urine sample provided had no temperature, and Ms. Watson had packed in fake urine or otherwise urine that wasn't her own. Due to the time constraints, policy and procedures of favor providing Ms. Watson the proper allotted time to produce a second sample, Ms. Watson was released and directed to report back on 12/24 at 8 a.m. to the Columbia Office of Probation and Parole. On 12/24, Officer Burton assisted in giving Ms. Watson a urinalysis, whereas Ms. Watson produced a sample that was positive for methamphetamine. When confronted about the conflicting samples and shown her the evidence of the sealed cup, Ms. Watson admitted to and signed admission of guilt form to consumption of a detox drink to alter the urine sample, as well as consuming abnormal amounts of baking soda and water and attempt to alter the results of the urinalysis.
So the way I understand this.
Excuse me just a second. Pre-trial. Go ahead, excuse me.
So the way I understand this, she appeared on the 23rd, could not provide a valid sample. Came back again on the 24th, provided a valid sample, was positive for meth. Is that correct?
That's correct.
And it admitted also that on the 23rd, she had altered the test by using this baking soda concoction that she uses.
When she reported on the 24th that morning, but she had attempted to alter again after her sanction.
And this is the second time you got her to admit that she's tried to alter the sample.
Yes, sir.
That's all we have.
You have any questions?
I have no questions,
Okay.
Mr. Garner.
Okay, so you stipulated that.
Yeah, I'm at kind of a horns of a dilemma here. Ever since House Bill 463 was passed 12 years ago, the people that have used substances like this and altered substances on a possession case that need to be hammered cannot be hammered by the Commonwealth. I'm convinced that Miss Watson, when she overdoses and dies, not if, but when, because she keeps taking these noxious substances to try to elude tests, she's going to get something bad someday and she's going to die. So I'm on the horns of a dilemma. I can ask the court to revoke her probation, and she's already got time in, and the parole board's probably going to release her in 30 or 60 days, and she's going to run wild till she gets caught again. Or Mr. Cross proposed sending her to rehab, and I thought, well, if she goes to rehab for 6 months, she went to prison, and I've sent her to prison before, the court has. We put her in drug court, that didn't work. And I thought rehab would be the last chance. So that way, when she does overdose and die, my conscience is clear. I've done everything I can to try to help her. So I don't know what to do with her because she needs to be in jail for about 2 or 3 years solid. It's what she needs, but I can't do it.
Your Honor, in response, I can't disagree with much Mr. Stokes has said. This court knows Ms. Watson, understands her background, her work record was marvelous for many years. Court's very familiar with her family. I hate to give up on her. Ms. Watson is again let down her family, the court that's been over backwards for her, Mr. Stock, myself, and herself. But that doesn't mean we need to give up on her. And if we can send her into a long-term rehab, maybe this is something that she will benefit of, and this court will keep control of it during that period of time. And I would ask the court to accept the agreement that Mr. Stockton and I had, send her on for long-term rehab, and maybe this will get her attention. I just don't know. I'm so disappointed in her, and I know this court is as well. And I've been to Columbia to see her, and I know she's disappointed in herself. And she says she needs to figure out how not to do this. She's simply a user. It's killing her, and it's killing her family.
I hate to be put in the situation of claiming I'm giving up on anybody, but I cannot treat her so differently than everyone else that comes in this court. She comes from a good family. She's well educated. She had a profession. It's not just that she's a drug user. She's a liar and a deceiver. And she has misused every opportunity that we've given, and she's made a mockery of this court and everything that's been done to her. I'm revoking her. She can serve her time. If the parole board wants to let her out, it's on their dime. It's not on ours. They need to consider what they're letting out. Maybe they will put some conditions on her, but I'm finished with her. Okay, thank you very much.
That's all I had.
Okay, Jimmy Otterson. Commonwealth versus Jimmy Otterson. Are you Jimmy Otterson?
Yes, sir.
This is 19 CR 0067. Mr. Otterson, were you born in 1991?
Yes, sir.
The last four digits, social security 9087.
Yes, sir.
You're on a shock probation revocation. What does the Commonwealth have to say about this? Or I guess it's your,
Your Honor, we weren't, it hadn't been too long ago that Mr. Otterson was in court because he had the vicious animal and he was warned about that. Now he has a new felony arrest where he allegedly assaulted a young man down at the car wash with a stick. That case is being presented to the grand jury today, so I don't know if we want to just take both of them up in case he's indicted at a later date or not.
let's put a negotiation date on the 13th and the next court appearance on the 26th. And Mr. Otterson will be held. If he is indicted today, we'll send a summons instead of an arrest warrant for him and make the adjustment. Make sure he's present. You need to do a transportation. Go up and talk to Mr. Otterson about these things and do a transportation order for him. To be here on the 13th at 9 a.m. for negotiation and 26th for the next pretrial. Try to roll these things up into one. Okay.
It wasn't that.
All right, there it was in that. Okay. Thank you very much. Your attorney will be up to see you, Mr. Otterson. Commonwealth versus William Taylor. Commonwealth versus William Taylor. 25 CR 0084. You are William Taylor.
Yes, sir.
You were born in 1995.
Yeah.
Last four digits of your social security number 3136.
Yes, sir.
Okay. You have a right to remain silent. Your attorney is here. The grand jury of Cumberland County has returned an indictment charging you with possession of a handgun by a convicted felon, possession of controlled substance, fentanyl, possession of controlled substance, heroin, possession of drug paraphernalia, driving on a suspended operator's license, and speeding. Counselor, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We're going to set a February 13th negotiation date and a February 26th. What's the bond on this?
$10,000.
That's your lawyer.
Is that sufficient bond? You think with
They understand that.
$10,000? $10,000 cash or 2 times property
I think that's easy.
and with a handgun and fentanyl?
Well, he's another, I think he's a co-defendant to Mr. Baker, and I think he's probably a Virginia resident. And I think I can't tell from the NCIC report, there was an assault that happened back in July. I don't know if that's still pending or what the disposition of that is in Virginia, so I don't think they've got a hold of him. He may not make it back. He does hold on.
Co-defendant to Miss Baggard.
I think that was his name, Inslee Mayer.
Right.
You have potential conflict there then?
I would think so, and I don't know which way we.
Maybe the bond should be increased until he gets an attorney to represent.
Yeah, I want to take the bond to 25,000 cash. And then we'll have the 13th and 26th. Mr. Taylor, it could be that you have a conflict with the young lady that was with you as far as attorneys. So they're going to check to see if you have a conflict, to see if you need a separate attorney. Okay.
Okay.
Okay. Thank you very much. Carol Walker. Commonwealth versus Carol Walker. 25 CR 0085. Are you Carol Walker?
Yes.
Were you born in 1965?
Yes.
Last four digits of your social security at 9875.
Yes.
You have an Office of Public Advocacy representing you here. You have a right to remain silent. The grand jury, of Cumberland County has returned an indictment charging you with burglary in second degree and criminal mischief in second degree. Counselor, do you acknowledge the identity of your client, received indictment, wait formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Have signed a reciprocal discovery order that require the Commonwealth to give you information, prepare for your defense. You'll have a negotiation day on February the 13th at 9 a.m. and a pretrial conference on the 26th of February at 9 a.m. Both of them are conditions of your bond. What is her bond?
It's $10,000 cash if we count property.
Okay, that'll be sufficient then. Okay. Thank you very
Your Honor,
much.
how much was the bond?
10,000 cash or $20,000 property. So anybody that's got
Okay.
come in and not a problem.
Hey, I need to ask my lawyer a question. I got a phone call.
No. The lawyer being contacted. You don't need to communicate. This is being sent out everywhere, okay?
All right,
He'll
thank
be in
you.
contact.
I'll be in touch with you.
When are you gonna be in contact with her?
I don't know, but it'll be before 13th.
Well, she might have a questions more pressing than that. I mean, can you call her?
Yes.
He's gonna call you.
Thank you.
Thank you. Austin White. Austin White. Are you Austin White?
Yes, sir.
This is 25 CR 0062. Mr. White, were you born in 1999?
Yes, sir.
Last four digits, your social security number 8022.
Yes, sir.
We're here for a probation revocation. What's the Commonwealth say?
Your Honor, Mr. White serving 12 months on a theft of deception charge. I mean, a 12-month sentence. He's got a new misdemeanor arrest, shoplifting at Best Buy, I believe in Bowling Green. He went to rehab and left after 2 days, and on January the 5th, he was positive for meth.
Judge, I saw Mr. White yesterday. We acknowledge the allegations. He wants to address his problem. He's obviously got a severe problem. He mentioned drug court. I know with it being a misdemeanor sentence, I didn't know how the Commonwealth feel about that, but he feels strong.
I don't mind. Judge Costello doesn't like taking misdemeanor cases, but maybe we can convince her. But I do think he needs.
Are these new charges, felony charges?
Well, the one in the Best Buy would be a misdemeanor in Bowling Green. Now, he's positive for meth, but he's not got a new possession case. So
his previous plea was to misdemeanor?
It was. This is the case where his attorney, Mr. Rutherford, talked us down from a felony to a misdemeanor. He come back and tried to set it aside on 1142. And I can see why now with all these problems he's having. He didn't want to be on probation. And then he's picked up all these new violations since then.
Well, I'm just gonna revoke the probation.
Okay.
Should never reduce it to misdemeanor. I shouldn't have. Well,
I shouldn't have either hindsight.
no good deed goes unpunished. Okay, Richard Whitlow. Richard Whitlow.
He's in 42.
Are you Richard Whitlow?
Yes, sir.
Good morning. This is 25 CR 0079. Mr. Whitlow, were you born in 1975?
Yes, sir.
Last four digits, social security number is 0884. Okay.
Yes, sir.
The pre-trial conference, what we have?
Judge, I was when I saw him last week, I was under the impression that he had hired private counsel, so really didn't get anywhere with the discussion or.
Did you hire private counsel, Mr. Whitlow, or?
It didn't go through yet, so, no, I ain't hired no counsel yet, but it's.
Okay, well, your attorney, I'm gonna schedule a negotiation day for February 13th. And the next court date is February the 26th, and on the 26th, we'll either have a plea or set a trial date, okay?
Your Honor, can I say something, please?
At your own risk, and you know.
Yeah,
Your
I
attorney,
have some,
your attorney would advise you not to, I'm sure.
Yes, that's correct.
this is concerning bond and medical issues. I have, my whole shoulders, my right shoulder has to be completely replaced with new titanium bones and everything. Like I'm in excruciating pain most all the time in here. And I'm asking if I could probably get a medical, like a house arrest, medical release or something. The doctor here told me to ask for that. Because I've got to have my shoulder replaced completely.
Get some medical statements sent by the doctor. They can send it to, you can send it to the public defender's office, or your public advocate here. He can sit down and talk with the Commonwealth about that.
Like I have a surgeon named Caleb Davis in Bowling Green.
I know that, but what I'm saying, we've got to have written medical documents from these physicians to your attorney so they can look at them to do that. I mean, I just can't we have to have documentation. I'm not saying we can't do that. I'm not saying that. But we're making no progress on your case right now, as far as negotiations and as far as you saying you're going to get an attorney and not get an attorney. That it might be through no fault of your own, but if you're going to have a public defender represent you, then you need to give him documents justifying a change in your bond condition, and I'll consider that then, okay?
Yeah.
Okay, thank you so much. Is there anyone else up there in Adair County that we need to speak to? Is that it?
That's it, sir.
Okay, we are released, and except for the show cause docket, does that complete the criminal docket?
Was Mr. Bricker going to be taken up?
Wait, Monroe County? Barron County Detention, are you on there?
Yeah. Yes, Your Honor.
Okay, if you will open up for Tamara Stamper. Tamara Stamper. Are you Tamara Stamper?
Yeah, I'm Tamara Stamper.
Tamara, excuse me.
Thanks, Your Honor.
25 CR 0010. You born in 1985?
Yes.
Last 4 digits of social security number 1699.
Yes.
Is that right?
Yes.
Okay, we're here on a pretrial conference. What's the Commonwealth have to say on this Monroe Circuit Court case?
We have a plea, and I'm looking to see if it's a felony or a diversion. I believe it's a felony plea, isn't it, Ms. Hill?
It is, yes.
Ms. Stamper, I understand that you want to enter a plea today. Is that correct?
Yes, that's correct.
Are you currently under the influence of drugs or alcohol?
Oh, Your Honor.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in the Monroe Circuit Court case 25 CR 0010?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney, and are you satisfied with her advice?
Yes, I am.
Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case?
Yes, I do.
Understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand these rights. I'm going to go over them at the end. I'm going to ask you to affirm that you understand them. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. The right to private Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. You understand that by entering a plea of guilty today, you give up all those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will order a pre-sentence investigation report be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you'll have the right to withdraw your plea of guilty, proceed to trial. What is the Commonwealth's recommendation, Mr. Stockton?
Your Honor, Ms. Stamper will plead guilty to operating a vehicle under the influence, fourth offense. She'll receive a sentence of 5 years, serve 180 days, balance probated for 5 years. Probation's be supervised. She'll receive credit for time served. After sentencing, she will enroll and complete a long-term rehab or transitional living secured by DPA and approved with Commonwealth. Afterwards, she'll either obtain gainful employment or do community service. All evidence in this case will be destroyed. Pay court costs discretion of the court.
Is that your understanding, ma'am?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
Are you doing so of your own free will?
Yes.
Or your constitutional rights I previously explained to, is it still your desire to give up those rights, enter pleading guilty to charges and allow the court to fix your punishment in the range permitted by law?
Yes.
You understand that by any guilty plea today, any future convictions of felonies could be enhanced under the persistent felony offender law.
Yes, I understand.
Okay, do you have a copy of her plea agreement there, counselor?
There's a copy right here. Megan did.
Okay, let me hold it up here. Is that your signature on there? Can you see
Yeah.
that?
Yeah, it is. I can see it.
I will accept the plea agreement or a pre-sentence investigation report. When's the Monroe Circuit Court day?
February the 19th, Your Honor.
February the 19th, sentencing on February the 19th.
Thank you,
Okay,
Your Honor.
thank you very much. Yeah. Now, did Eastern Kentucky Correctional Complex get on finally?
Thank you,
Did
Judge.
we ever get them all? Thank you. You may be excused. Thank you.
I thank you too.
Paul Bricker was at Eastern Kentucky Correctional Complex. What kind of pretrial who is his
Well, he,
attorney?
according to Ms. Costello, and she communicated with me by email that we'll need a trial date, but he's currently serving at least a 12-year sentence, so I would think sometime in the fall or later in the year, get a trial date.
Continue this to October the 22nd.
That way we can get a trial date then.
We'll get it on October the 22nd. That concludes the criminal docket except for the show cause. Show cause is Brandy Franklin.
No, she's been paying it a little, she just didn't pay this month.
How much has she been paying?
She paid. I should have paid 21.
Okay. Do a show cause to let her satisfy that with a $50 payment, and then we resume regular payments, okay? Todd Howard.
But he's not my payment,
Is this for restitution or what is it for?
I think it's the deed.
Okay, issue an arrest warrant, $875. That concludes the docket. Okay, I guess we're ready for the grand jury. Are they finished?
Yes, sir.
They're ready. Okay, let me go off the record here.
Okay.
versus Kohler.
Good afternoon, Your Honor.
Hello.
I'm fine, so I'm Zoom, Your Honor. I think those can count, you may be also, or no. See, court. Oh, your attorney can be appearing in person.
She's waiting for an updated Zoom link. Well, she can wait a long time. I don't know what that means.
She called her office and Megan asked us if there, so we had to contact her, so something. That was about 10 minutes ago.
Tell her. See if Megan, are you on there? You've seen this lady at Zoom link?
She's not wanting her.
You need to tell your attorney, where's she supposed to contact her at?
She got her email.
You need to have your attorney contact my staff lawyer by email to get the Zoom link. We'll pass over this case back. Connor versus Connor.
Good afternoon, Judge.
Hello. Okay, who have you served with this motion for name change?
Mr. Honeycutt. And we'd also served Ms. Vaught, and she had signed a waiver where she didn't object to it.
Have you received a spot? Is Mr. Honeycutt incarcerated now?
He is.
Well, does that bring a problem as far as having somebody to represent him since he's there?
We had filed a petition originally in district court, and Ms. White was appointed, but they objected in district court because we had the circuit court order, so that's why I filed the motion here.
Yeah, but I'm talking about the fact that he's incarcerated.
I think if he's present, Judge, and this is not.
Is that him online there?
Yes.
Yes, Your Honor.
Mr. Honeycutt, do you have any objection to this name change?
Yes, Your Honor, and I do need to locate an attorney so we could put it off for a hearing. In their statute for proper notification, 60 days to schedule a hearing.
Judge, I'm not sure what he's referencing. We filed it timely within the court's local rules of when you have to have a motion filed before it's heard.
I was just notified 2 days ago about this court date.
Might be, I don't know.
I had my son too.
What, who are you?
I'm here.
You're his father?
Yes, sir.
Well, you can't say anything here, okay? I'm sorry, I don't want to be rude. I just heard the voice come. I didn't know.
I'm sorry.
There's no problem.
And Judge, of course, we're not asking to remove the name Honeycutt. We're asking to add Connor.
Well, how long, Mr. Honeycutt, are you incarcerated for? Do you know?
I should be out in the next 6 weeks, 5 to 6 weeks.
Well, I'm going to go ahead and appoint someone to represent his interest since he's incarcerated. I think that's the only reason. Who's next on the list?
One will work and district court, in this way, we can't get that change.
So she's already represented. Well, I'll continue Wanda White's representation and have her present here on February 26th, and she should have consulted with him.
And I'll renotice the motion and include
Yeah,
Ms.
I
White.
really don't see how he's harmed very much by a name change, They're not trying to eliminate your name, Mr. Honeycutt.
I understand.
Do what?
I understand. We had in the civil action that went June 11th and 24, we both agreed that neither parent may engage in the child's surname without permission from both parents. That's something we agreed to before any of this even started.
You'll need to tell your attorney about that. We'll be back here on February 26th. And if your attorney decides they want a transportation order to have you here personally, I will sign one. Okay?
Okay, thank you.
Okay, thank y'all
All
very
right,
much.
thank
Vanderpool case. I don't see anything in here on that. What was that?
Judge, I think Perigin is speaking with her client, if we could recall that for just a minute.
On the Vanderpool case?
Yes.
Okay. Tax Break LLC versus Larry Murray. And others.
Good afternoon, Your Honor. Shane Sorensen with Dietrich and Spies on behalf of the plaintiff. It's our motion for amended complaint.
Okay.
There's been two responses filed, I don't think they said it is.
Do what?
There's been two responses filed, and you have seen, there wasn't filed.
And Marty. Oh. There have been a couple of answers filed here or responses that I don't think were e-filed and probably weren't served on you.
We received one response.
From Alicia Comer.
Yes.
Okay, they emailed this one, and the other one is from Stacy Murray. And it did not. Are you with R. Eric Craig?
Yes, Dietrich and Spies, yes.
Yeah. She said she served that on you too. Comes Stacy Dollar, I am filing a response, submitting a complaint. I declare that I'm not the executive of this state. There is no estate of my deceased father. No legal interest obligations. I have no.
He died intestate, so legally we have, or by Kentucky law, we have to list the heirs that follow him. And so we do have to list her, but she doesn't have any in personam liability. We just have to have her name in rem.
Well, I understand, but don't you have to, as a creditor, don't you have, if there's no estate established, don't you have to come in as a creditor and establish an estate? You can do that, can't you? I don't see how you can get a judgment against a deceased person where there's no estate in existence. You have to file claims within a certain period of time against the estate. If there's no established estate, many times the people that are the debtors go in and petition to have an estate established, and they become the not the executor, but they become the administrator. In cities, sometimes they have public administrators who do these things, but we don't have that country. So, I mean, what legal status do you have to get a judgment against a deceased person if an estate has not been filed?
I would have to refer to Eric Craig. I'm taking this case over for him, so I would have to kind of see.
Eric's giving you a good one, I can tell you that. So.
Yeah.
I just don't see where these two ladies who might be potential heirs of his are parties if there's not been, there could be other people too. Right? You don't know. So I would petition the district group, check with your senior there and see if, you know, that you need to establish as a creditor an estate here. Did Larry Murray, was he a resident of Cumberland County when he passed away?
I believe so.
Okay, well, just check into that. I'm not gonna rule on your motion to amend yet. Just pass it over. My next rule day here is on February the 26th, okay?
February
I might
26th,
be
you said?
wrong. Yeah, I might be wrong. If I'm wrong, you just send me a response, show me under what right you'd have to amend and name these people who have no interest in our administrators, okay?
Okay, and you said February
I think-
26th, correct?
Pardon?
You said February 26th?
February the 26th at 1 o'clock or 1:30, one or the other, okay? Thank
Okay, thank you.
you very much. Bank of Columbia versus Paul Bricker. Okay. You represent the Brickers?
I represent Krista Bricker, not Mr. Bricker.
Yeah.
Mr. Burger is in Eastern. He's the one that did not get on Zoom this morning for.
Okay.
And here, Your Honor, and it's nice to see someone I went to law school with still on the bench. Um,
I was a young person younger than most other people in my class.
well, you were younger than me, in fact. You were the class behind me. But I represent the bank in this case, and I've spoken with Angie a bit about the case, and if she wants me to just tell the bank side of the story first, then we're going to try to see if we can work this out. Here's what has happened, Your Honor. Mr. Bricker is in prison. I've been told it's for maybe some felonious acts against the wife and the kids, but I really don't have insight into all that. But we've gone through great lengths to speak to him in the prison. He's had a warning order attorney appointed for him, but this is a mortgage loan that there has not been payments on for some time. And my client, the Bank of Columbia, has told me to go ahead and move for a judgment. So with the warning order attorney report filed, he's before the court, and I don't think there's any doubt that they have not been making payments. Having said that, recently Miss Bricker has gotten maybe a temporary award of some of his veterans benefits, and she is requesting a bit of time to try to sort this out. Well, the problem is she can't sort it out with her husband unwilling to sign anything. He did write a letter. He doesn't want the property to sell. He doesn't have any defense, but he just doesn't want it to sell, and he's unable to make the payments. I'm sure because he is in jail for some lengthy period of time. So what the bank wants to do is to get the judgment signed, but give 30 days to Miss Bricker to get in the divorce court an order to get this property over in her own name. Now, I'm not saying that the court can do that, should do that, but we can't do anything on this with him in jail. We just can't do anything but sell the property. And I know that Miss Bricker has a number of children. The bank is not, she really probably doesn't have the money to do this all on her own, but she has a plan to sell some of the property off. But we've got to know that there's an order signed that the property and in order the master commissioner to sign this right away, and I guess you have to wait for the appeal time, but otherwise, a month from now, they would want to file a motion to set this for hearing to go ahead and refer it. But at this time, we just want the judgment and give And she's been
Wait,
working.
wait just a second. Let her talk for a second.
Okay.
We've had a discussion about if the bank got the judgment, they were gonna hold off on proceeding for the master commissioner sale for 30 days so that I can get something before the court to try to see if we can get an order where the property is assigned to my client.
Is that in a judgment already? Is there a judgment in the?
It is not. This is one where.
I just don't see how that can be done in 30 days. How, how the court could rule to award her the property without, I mean, he's not available.
Well, Judge, there was a hearing done quite some time ago. I filed a motion for entry of decree. And so we were gonna see if we can't get the decree entered, if we could go ahead and file a motion just asking award to where she
I
can make.
thought they were supposed to be working on the settlement between the two of them.
That's not, I think Mr. Cross came the last time we had a motion on before the court. And then there was no other communication with Mr. Bricker, and he indicated he didn't know if he was gonna continue representing him, but nothing was filed.
Are there any other assets other than this mortgaged piece of property?
No, and we put on proof that she had a substantial non-marital interest in the hearing and that she had been making the payments during the time because I think he became incarcerated very soon after they purchased this property.
So her only relief then could very well be a court sale to defend her position and then divide the money according to the judgment that I enter in the divorce decree. You think that's
Yes,
true?
that, or if the court awarded her the property in the decree itself.
Well, if I awarded the property decree, there could be an appeal filed and it could take a year.
But I've talked with Mr. Hinton about that and we understand, the 30 days may have an appeal issue to it. So we've been in communication about that and discussed
I
that.
just don't feel comfortable even with the evidence that's been submitted to award somebody a piece of property in toto. I'd feel more comfortable ordering a sale of it and then you could divide the proceeds are fungible. And I can determine who's entitled to what. Of course, you do that. Does she live on this property?
She lives on this property with her children.
Somebody else might come in and buy it, is what you're
Yes.
saying.
And she has a plan and we've went over it with the bank. She has a purchaser that would help basically pay off a substantial part of this mortgage. And so that's the other issue.
Well, if I order it sold and if it's not sold at a commissioner's sale, if someone comes forward to buy the property, there would still be the problem of his interest not being extinguished.
That's
Is that
correct.
right? So I don't see where it's gonna work other than just order a court sale, give a judgment, have a master commissioner sell it. And if he wants to negotiate with your client, he can. If not, as my old professor used to say, we'll just have to lay where Jesus flings them, Okay, well, I'll do the summary judgment and order of sale and send it to the master commissioner.
May I say one thing? And this I would leave totally up to Angie if she wants us to do this. I'll have to speak with my client, Your Honor, and then I would call you or your assistant as you would direct. There is a current statute that allows a realtor to work in conjunction with the master commissioner to really try to bring a whole lot more money. That can be paid up to 6%. And
I don't do that.
okay.
I don't like that, is this a huge piece of property?
It is, Judge. And the other issue is my client has provided funds that I'm holding in my escrow account that essentially we could catch the loan up, but the bank was not wanting to do that. So, I'm just trying to preserve her ability to keep a roof over her children's home because unfortunately she's been put in this situation.
What's the amount of the mortgage that they hold, that you have?
Well, the amount of the mortgage is $147,855. There have been significant costs and everything in trying to get warning orders, and it took hours and hours and hours and hours just to get set up to be able to go through the judicial system, to be able to talk to the guy and to get registered to do that for the bank. This case has been an ordeal, and we don't mind if they want to sell. There are two different lots described. I can't tell you which one has the home on it, but I don't mind selling it in two different tracks, and I could tender a judgment to that effect if Miss Bricker has someone that wants to bid on the vacant tract.
Wait a second, wait a second.
We've not had it appraised at this point, Judge, because my client doesn't have the funds for that.
Well, nobody believes it's upside down though, right?
No,
We
It's not.
we don't know.
How many acres is it?
Let me look, please, Your Honor.
hang on just a minute, Judge. I've got it right here in front of me.
One tract is 20 acres, more or less.
The other one doesn't give an acreage in the. Okay, it doesn't give an acreage in the other parcel. But I know it's substantially more than 20 acres.
Look what the PVA says, it's 31 total, and it is in two tracks. So,
Total of 31 acres?
yes, sir. And we could agree that the tracks as described it, and I could submit an order to that effect, supplementing my judgment, allowing the property to be sold in two tracks.
Well, the master commissioner can make that decision when the master commissioner gets it. If it's one piece of property on the mortgage where they sell it in two tracts, if they're separate tracts. Master commissioner's here in court today.
Okay.
Judge, I would ask if Mr. Hinton, on behalf of his client, is willing to do that, if we could do that, because again, this woman has been a victim, her children have been victims.
Asked to do what? You lost me. You'd asked Mr.
As to them allowing to section off just the tract that is not where her residence is.
Well, I would sell it all, but I would sell it in two tracks if you've got a bidder that's going to, in a competitive bid more and get your client more is what I'm saying.
You want to do that?
I mean, if that's the only option that we're being given is the alternative to
Well, I don't know
keeping
any
it.
other option that you can have since there's a dispute on the ownership of it. And to say that the proceeds be paid first to the cost of the mortgage and any cost of litigation. And Mr. Hinton, I don't know how much trouble you had getting these people, but you know, I'll have to prove the cost associated with the suit, and I don't award large amounts usually. You know, I mean, I don't know. I mean, what do you think your costs are going to be in the sale?
I think we added it up and it was about $4,100 so far in the last year and a half of doing this. It's not a real big one, but
okay, well,
you know, it's legitimately.
I'm gonna sign an order giving a summary judgment and order of sale and direct the master commissioner by the agreement of the parties to sell it in two tracks.
Okay.
And then after the sale, the proceeds will get reported by the master commissioner, and then everybody can lay their claim on the final judgment on after we do the division of the monies. And then Mr. Bricker and Miss Bricker can fight it out on who gets what's left.
Yes, sir.
Okay?
Thank you, Your Honor.
Okay, thank y'all very much.
And nice to see you.
Good seeing you. Yeah. Epling versus Anders.
Good afternoon, Judge. I'm here on behalf of Mr. Samuel Lee Anders.
Is Mr. Epling here?
It does not appear he's here.
You want to come forward, Mr. Epling? Okay, you, Mr. Epling, tell me what your story is, Mr. Epling.
Well, I came to Burkesville last March. I was doing a lot of fishing and some work and get a piece of the community. So I started in with this house. Got, and it had some problems and I overlooked them. And in the meantime, I was upgrading, well, stuff that should have been in there that had not, was not in there. And, then comes, June, I mean. And I get this nasty letter from Tri-County telling me that my electricity was out of compliance and that they were gonna connect me at the end of the month. So
On the 12th day of March, you bought a piece of property from Samuel Lee Anders. And it was on Hill Street, correct?
yes, sir.
Okay. And thereafter, you found some problems with the electric code. Were there other problems?
Yes,
Or
there
is
were
that the
others.
main problem you have?
The main problem is the electric because it's.
Okay, now then John Phelps was the real estate agent involved. And there was a disclosure statement, right?
Yes, sir.
Okay. And you said that things in the disclosure statement were a lie. Correct?
Of course,
Okay.
yes.
Which particular?
Part of the,
Yeah, I mean, I don't see the thing about the electric code.
well, on the second page of that form, it has systems and one of them is electric system.
I'm looking for that. Yeah, I see it. And it says no.
No, he doesn't see any electrical problems. When
Whether or not housing systems, whether or not they have been corrected, state whether there have been problems affecting the electric system. And he says, no, there are not problems. What you're saying that says. Is that right?
that's what he says.
I mean, that's what your interpretation of this document is. He's
I'm
saying
saying
no.
that is a lie.
Well, you're saying it says that there are no problems with the electric system, correct?
No, there's problems. There's illegal problems with them.
No, sir. You listen, in this disclosure statement, he's telling you that there are no problems. But when you went there, you found out that there are problems.
Well, yes, sir, when
Okay, well, are you gonna answer me?
Yes, sir.
Okay, this is what, I'm just trying to get your statement down. He told you in this disclosure, whether or not there have been corrected, state whether there have been problems affecting the electric system. He says, no, there are no problems. Okay. Then you go onto the property and you're saying that Tri-County is going to cut your electricity off because there are problems.
Yes, sir.
Is that correct?
Yes, sir.
Okay, now what's your response to that?
Judge, my response to that is by Mr. Epling's own admission, there were problems with the property that he blatantly
No,
overlooked.
I'm talking about the electric system. I was just talking about the electric
As
system.
far as the electric system, Mr. Anders was under a legally binding contract with Southern Nest Realty that offers him the chance for an inspection by a duly licensed electrician, contractor, any of the sorts, at which he denied all of that.
Where is that contract here somewhere?
I believe it is my exhibit A.
How much would it take to get you in compliance with electricity?
I've talked to two electricians. One guy said, $4,000 to $5,000 and another one stopped counting at 6,500.
Where is that contract?
The contract is right here as my exhibit A. I can produce you a copy, Judge.
Well, Says the buyer accepts the property as is, including not limited to the interior, exterior of the roof, the facade, the floors, the ceilings, all systems, including plumbing, electric, heating, windows, the concrete driveway, the sidewalks. The buyer acknowledges the buyer has had an adequate inspection to ascertain the condition of the property and the property as is based upon the buyer's inspection. What do you have to say about that?
I say that there was a Supreme Court decision in November of this year that said that the as-is clause is a less
Supreme
of.
Court of Kentucky or United States? Kentucky Supreme Court?
Yes, sir.
Yeah.
He said, it said that the less that as-is clause is a less of an argument or excuse me. Anyway, it was a very similar case to mine. And what happened
What's
was
the name of the case?
Cumberland, Semer.
Do you have a citation on it?
Yes, sir. But basically.
I want the citation basically.
Okay, I'll find it here. Oh, paper, oh, paper.
Are you familiar with the case?
Yes, Judge. And in my opinion, it would appear that Mr. Phelps and Mr. Anders executed a contract for the listing of a real piece of property located in Cumberland County. If there's any issue at all, it would be between Southern Nest and Mr. Anders. Without Mr. Epling's involvement, he had his chance to duly inspect the property.
What would be
hire his
the
own-
issue between Anders and the real estate company?
I'm saying if there is any issue,
What would be, if there is, what would that issue be?
the,
I don't see where there could be any issue between the real estate company, Mr. Anderson.
I.
You say that this gentleman here in the sales agreement signed an agreement where he said he would inspect it. This
He had the
signature,
opportunity to elect to inspect and.
he signed this agreement. The gentleman signed an agreement that says it's as is.
Correct.
Mr. Epling, I see his signature here, and it's dated, and he signed as is. And Mr. Epling says there's a Supreme Court case that says that as is doesn't mean as is.
Sir, can I correct that? That the as is not as good a argument as the KRS that says that purse.
I could even help him out. As is, that's fine. We don't need as is. Was there any warranties, guarantees, or assurances gave to you about the property?
What's the case say that you got?
I don't have the case that Mr. Epling continues to refer to.
Well, it's freely available on the internet.
Well, everything in the world's freely available.
Yes, sir, it
Unfortunately,
is.
I will not take everything that's on the internet up to date.
I'm sorry, it's out of order that I'm doing this here. Okay.
Are you familiar with this case he's talking about?
The Supreme Court case, I'm not.
He doesn't have a citation on it. I'm gonna tell you what I'm gonna do. I'm gonna pass over this for a minute. You go back one of those rooms, gain your composure and find out the citation. I'll let you come back out. Okay?
As in, yeah, okay.
Okay.
Excuse me, I'm sorry.
Okay, does anybody else have anything on the docket today that we passed on? We'll come back to. So you got the Vanderpool case.
Judge, on the Kohler matter, I've emailed with Kohler here, I was going to talk to her about if he's apparently contacted his attorney. I have emailed her several times. I got a Zoom link from Megan and yesterday for my client. She utilized it, and I've sent that to her multiple times via email.
Have you been in contact with your attorney in the last few minutes?
I have.
What kind of relief did you want today?
All we're here for, Your Honor, is enter the scheduling work reviewed and set for a final hearing. I just had some basic terms that to file the final property disclosures, but according to the rules by January 31st. Discovery on non-marital tracing to continue through March 1st. And set dispositive motion, any dispositive motions to be heard on March 26th. And then set the final hearing date on March 26th.
March 24th, isn't it?
Well, what it, yeah, it could be 24.
March 24th.
That's it.
March 24th. I'll enter that order. That won't prejudice you any, sir. This order will not prejudice you any. It will just tell you the dates that this discovery has to be finished. And also include in the order that this attorney will not be allowed to participate by Zoom anymore, that she must be present. Your attorney has to be here next time. I'm not going to fool with this Zoom when she says she can't get to it. This order that I'm entering will not prejudice you in any way. It just gives her a schedule where she has to comply with the various discovery in this case, okay?
Okay.
Thank you.
Well, I mean, what do you not understand about that? This,
One more time.
okay, this order, give him some of those earphones there. What do you say? I'll tell him.
Let me go on this thing. Sorry, that's okay.
Go ahead.
I don't know, he should.
He'll give you some earphones.
Did you at all talk to her on the phone?
No.
Okay, okay.
Okay, put those earphones on. Okay, can you hear what I'm saying? Get back there. Can you hear what I'm saying better now? Can you hear what I'm saying? Okay. We're entering an order here. Your attorney did not show up. I'm entering an order that he's submitting that gives the schedule where she's got to comply with discovery, where they exchange information. He's got to give her information about your case. She's got to give him information. It schedules it, and it schedules it all to be back here on March 24th to have any motions on this. So nothing's doing that will damage your case today. I'm also including in the order that she cannot participate by Zoom again because she didn't show up and we've been trying to contact her, and I'm not going to go through this every time. She should be here in person. Okay. Okay.
Well,
Thank you. Thank you very much.
Thank you.
Yeah. Okay, let's go back to the Eplin case. Where did Miss Perigin go? Will somebody get Miss Perigin back in?
I think that
Wait
case,
just a second till Miss Perigin gets back up here, okay? Okay, sir. You have a citation on that case?
I have a. Yes, sir. I'm not really. Well, I think we're stuck together. Okay, the case was Lewis Simmerling et al. Versus BPP LLC DBA Black Pearl Properties LLC.
What's the citation? That's what
I think
page
it was
and book?
it was unpublished, is that?
It's unpublished.
Yes,
Well, that means that you can't use it as authority. If it's unpublished, it means that the facts of that case apply to that case, but cannot be used as precedent. Is my legal counsel correct on that?
well, the reasoning, do you want to know the reasoning between the law of the law?
It's not the law. It is a case, an unreported, unpublished case that the law only applies to the facts in that case and cannot be used as precedent to rule in other cases.
Well, apparently, well, they down there in Murray, when this went before the Supreme Court, but the thing is the legal, is the KRS. I mean, we've stamped all over the Kentucky regulations with both this Form 402.
What do you have to say?
And
Wait just a second. What do you have to say?
Judge, this appears to be grounds for a dismissal. I do not believe he's stating any
Well, I mean,
genuine issue.
what KRS are you stating, sir? Kentucky Revised
well,
Statute?
the one KRS 324-360.
And it says what?
It's the Kentucky Real Estate Commission Form 402 that requires by law somebody to lawfully submit that form, which in this case, the plaintiff didn't do that.
He's saying that he wasn't aware of any electrical problems and nothing had been done to fix it.
Well, I mean, there was electrical problems. I've got
Are you saying he knew about them?
yes,
How do you know he knew about them?
he couldn't have, because he oversaw them being made. Plus, I mean, my electric wouldn't been pulled if Tri-County didn't think that I was out of compliance.
I'm not saying that you weren't out of compliance. You're
Well-
saying he intentionally misrepresented something to you. Is that
It
what you're
looked
saying?
like it.
Well, it looks like it to you. You know, it looks like it. What are you saying?
Could I,
Judge, I see no proof of any type of misrepresentation. And additionally, Mr. Eppling has been offered numerous chances to get a licensed professional to look at the work before making the purchase and chose not to, and now seems to have buyer's remorse.
well, could I add something to the court that I didn't give in yet? I can got a copy if you want.
I'm going to object on authentication.
What is it that I'm not going to take it yet, but what are you talking?
I've got pictures of fully I never had a stutter until all this.
Well, I
stuff.
broke out in a cold sweat the first time I had moved court in law school, so it doesn't bother me that you're stuttering and have a cold.
Oh,
This is
well,
not your
okay.
usual place, so don't let that bother you. Here's my
I have
problem. If
pictures
you got, let me just tell you this. If you got pictures of something that shows that the electric system was not adequate, that's what you're talking about, right?
No, that it was there
What was
at
it?
all.
It wasn't there at all?
It
What
shouldn't
does,
have been.
wait, what does the picture that you're attempting to tell me, what does it show?
It shows an electric oven, electric lights and electric air condition, and it shows a ceiling fan and bright lights. A lot of lights. And it shows electrical outs.
What does that prove?
It proves that there was more than the electric certificate of approval on 7/20/22.
Now, what does it show? What does it show, though, your pictures?
What?
What
It
does
shows
prove?
that this stuff was put in there after the electrical inspection was made, which is illegal. And it's illegal.
Well, was the electrical inspection made after you bought the property?
No, the original approval.
No, I don't want original or this date. I'm just asking you a simple question. The electrical inspection that you're talking about that found that it was not adequately,
Well,
when was that done?
7/20/22
And when did you buy the property?
for shop,
When did you buy the property?
but
When did you buy the property?
March 12th.
Of
The same year?
Can I just add one?
I'm not asking you to add anything. I want you to ask a simple question. You
Well,
bought it, wait, you bought it,
If you want my date on a thing, I got it on July of
Eh.
16/20/25.
okay, now when was this inspection that you're talking about done?
This is one.
The inspection, when was the inspection done?
7/16/25.
So this year.
And you
After-
bought it last, you bought the property last year.
No, bought it,
In
bought it this year.
22? Did you say you bought it in 22?
25, 7/16/25.
Is the date you bought the property,
Or
right?
the inspection
Yes.
day?
No,
No, it was the
when did you buy the property? The date you
March
bought,
12th
of what year?
of this year. Or excuse me.
2025.
25, yes.
And the inspection that you're talking about happened in July, 3 months after you bought the property.
Yes, sir.
Okay, well, what does that have to do with this case?
Well, it said, the inspection said that it was out of compliance.
Yes, but sir, you bought the property in March and you had an opportunity to inspect it and you didn't. And then 3 months later, at your request, they went and did an inspection on it, correct?
That's right.
Is
because
that
I had-
correct? Is that correct?
Yes, sir.
Okay.
Judge, he absolutely had the opportunity to do this inspection January, February, anytime prior to 3/12 and chose not to. And he elected to do it after he made the full purchase price. And again, this is a simple case of buyer's remorse.
Well, I'm gonna rule that, and you can appeal my ruling, that you preserved your argument. I'm gonna rule that you bought this property as is, that you were given an opportunity on the contract to inspect all the systems, including the electrical system. You did not do that, and some 3 months later, when you did have it inspected, you found that it wasn't in compliance. If I'm wrong, the Court of Appeals will overturn it, okay? Thank
He
you very
broke the
much.
law.
What?
He broke the law twice.
Well, I don't know what law you broke. Go ahead. If you will create a judgment and get a summary. And then also, you need to, I guess you need to look and see how many days you have to file an appeal. I think it's 30 days from entry of judgment. But you need to make sure of that. And I would contact a lawyer if I would. Okay?
You know, lawyers these days
I don't want to hear your complaint
All
about
right,
lawyers.
thank you.
Yeah, thank you. Have a nice day. And I guess this goes to Miss Terry. Okay, now, is there anything else that comes before the court today? The Vanderpool case, okay. Okay. Do we have a DEO after this? Okay. What do you have now?
Judge, we had previously mediated and reached an agreement in the parties' divorce action. We've held off on filing the decree because they were gonna file jointly on the taxes and split the return. I think we were just reviewing to kind of see how the timeshare had been going and if there were any issues that we needed to bring to the court before we submitted a decree. I've spoken with Ms. Perigin. I think there's just some concerns about paramours because we had previously agreed in mediation that the parties were not gonna start introducing paramours to these children until things were finalized a little bit longer after because of the age of the children.
Judge, we proposed a 3-month or 90-day stipulation, for each party that once they begin dating, moving on with their life, if they can have a stable 90-day relationship, that may be an okay time to introduce a paramour to the children. Because eventually everyone is going to move on with their lives.
Not everybody does.
That's true.
But we're in agreement with that condition.
Are you? You are? Well, if y'all in agreement, that's fine, you know. Is there anything else?
Thanks, Judge.
Will this finish this case here?
Once we take my client's deposition and we submit the decree, other than them just dividing, because we've already structured and set up a separate bank account for the tax return to go into.
Well, what deposition do your client just,
Need to do jurisdictional proof. We
let's
can-
do that now.
Okay.
You raise your right hand, swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Please lower your hand. You can ask the jurisdictional questions.
If you would you please state your name?
Dakota L. Vanderpool.
And Mr. Vanderpool, you're the same party that filed for divorce action here in Cumberland Circuit Court against Brianne Marie Vanderpool?
Yes.
And do you all have any children in common?
Yes,
How many children do you have?
2.
And what are their initials and ages?
It's LMV and FAV. One is 5, the oldest is 5, the youngest is 3.
And have you all previously mediated this case back in November the 10th of last year and reached an agreement that addresses all issues concerning custody, timeshare, as well as division of marital debts and marital property?
Yes,
Okay. And did you do that of your own free will?
yes,
And do you believe that Ms. Vanderpool also did the same?
yes.
Okay. And approximately how long have you all been married? Or what was the date you got married? Let me ask that question.
It was 2020.
Okay. And when did you all separate?
About the middle of 2025.
And have you all continued to remain separate and apart for more than 60 days since that original separation date?
Yes.
Right. And to your knowledge, is Ms. Vanderpool pregnant?
No.
And are either of you all members of any of the armed services or veterans of the armed services or members of the reserves of those?
No.
And are you asking the court to go ahead and grant this divorce?
Yes.
That's all that I have, Judge.
You have no questions, James?
No, Judge, just one clarification with Ms. Katz. We had discussed the family issue. Are we okay on that?
I don't think that he was in agreement about that
What?
part.
What family issue you talking about?
Judge, we just have an issue where there's some limited contact with Ms. Vanderpool's sister, due to some allegations with the child's father, with being.
You know, we said earlier that the father, well,
I think it's her sister's boyfriend, who is also the
Yes.
father of the sister's child.
Yes, we've got some stipulations, regarding contact there.
well, let's just leave those in place for 6 months or so, and if y'all want to come back and review them, you can at that time. Okay, put that in the agree. Okay, thank y'all very much.
And then, Judge, there's one other thing that I think didn't want to make it on the court's docket, so I was gonna ask for that back for separate things.
What is it?
It is in Herschel versus Herschel. We were just asking for a hearing date. I think back on August,
Who's on the other side?
that would have been Mr. Michael Herschel, and he didn't appear for the last court date that we had.
Well, give him a notice. You want next rule day, the next rule day you want it? Just go ahead and sign an order, and if he has any objection, he should file it within 10 days. Okay? Okay. Okay, does that include the civil docket? Okay, we got a DBO here. Where is my? My phone. Okay, DVO docket. Mowers versus Key. It's due to expire on 2/23/26. Is there any request? Okay, it shall expire then on 2/23/26. Costello versus Harris, we have had a request to extend it for 2 years. Okay. Okay, extended for 2 years. Can you see my phone's back there? Okay, now we got a confidential docket situation here. Anybody that's not involved in 25 AD Henry Newport.